This video is based on publicly available court reporting and intended for informational and educational purposes only. All individuals mentioned are presumed innocent until proven guilty in a court of law. Before we get into today's update, we are officially on the road to 1,000 subscribers, and your support really means everything. If you enjoy content like this, please take a second to like the video and subscribe to the channel. Today's court appearance has brought major developments in the case of suspended police sergeant Fannie Nkosi, who has firmly denied all allegations against him, claiming that the state has a weak and non-existent case. Let's break down what exactly happened in the Pretoria North Magistrate Court. Nkosi appeared in court on the 13th of April 2026 for his formal bail application following his arrest earlier this month by a task team linked to the Madlanga Commission of Inquiry. He is facing serious charges, including defeating the ends of justice, possession of illegal ammunition and explosives, and theft of police dockets. However, Nkosi, through his legal representative, strongly rejected all accusations. He told the court that the allegations are merely fabricated and part of a plot to victimize him.
I wish to state I wish to state that the state and or prosecution has no case against me or is weak or non-existent, and this is the plot to victimize me. The state and or prosecution also charged me with the possession of stun grenades, and I dispute that the police who came to my house found a stun grenade, and this charge is fabricated against me. I contend that the state and the prosecution will not be able to prove this charge against me. The state of prosecution case is non-existent and weak against me. I wish to place it on record that in October 2025, the same members of South African Police Services who were working under political killing task team are the same members of the South African Police Services who are working under national task team, and they searched my house in 2025 without the warrant of arrest. At the time when they searched my house in October 2025, I was in possession of the firearms that I am charged with, and those firearms were kept in the same safe that were in when I was arrested. And this safe is mounted in the wall of my house, and this matter is brought against me as a result of the testimony that I gave in the Madlanga Commission. At flight risk, I will stand my trial should it proceed against me. I now have become a well-known sergeant in the South African Police Services. There is no possibility that I will even think of not standing my trial should there be one. I trust the South African legal system, and that the facts will show that I did not commit the offences that I have been charged with by the state and or prosecution. In order to persuade the above honorable court that I should be released on bail, I provide the following additional facts and information in terms of Section 60 that need to be considered by this court in this application. At Section 60, subsection 4A, read with Section 60, subsection 5 of Act 51 of 1977. I do not know the identity of any witnesses upon whom the state will rely in order to attempt to prove the case against me, besides the police officers who were present during my arrest and executed the search warrant in my property. In any event, I have no intention to interfere with any witnesses, as I have no cause to do so, and I undertake not to do so. I contend that there is no likelihood that if I'm released on bail, I will endanger the safety of the public, any person in which the offense was allegedly committed against, or a particular person, or that I will commit a Schedule 1 offense.
In his affidavit, Nkosi argued that he is not a flight risk, stating that he has no assets or business outside South Africa, he has no relatives abroad, and he has never been convicted of any criminal offense. He insisted that all firearms found at his home were legally licensed and stored in a wall-mounted safe, as directed during the police search. Nkosi also denied that firearms were found under a bed or inside a vehicle, calling those allegations false. On the charge relating to police dockets, Nkosi says the documents were part of his official duties, within the task team dealing with violent crimes and cash in transit cases. He further denied claims that a stun grenade was found at his home, calling that allegation fabricated. Nkosi also told the court that he poses no danger to the public or witnesses, adding that he has no violent crime charges against him and he has no reason to interfere with the investigation. His family, he said, is able to afford bail set at 10,000 rand. The case has now been remanded to the 20th of April 2026, where proceedings are expected to continue as the court considers the bail application and further developments. And if you found this update insightful, don't forget to like the video, subscribe to the channel, and share it with others. We are on the road to 1,000 subscribers, so your support really goes a long way, and I truly appreciate every single one of you. Also, drop your thoughts in the comment. Do you think Fannie Nkosi is being victimized, or does the state have a solid case? I read all your comments, so let's discuss. And I will surely see you on the next one. Bye bye.